Did they do anything in the beginning of this? All right, we can hang around. We can watch this, you guys. It's a beautiful, beautiful wall. What did they have on in the beginning of the stream? Oh, this is what their login looks like. All right, they've got a little. Oh, hold on. This is real quiet.
On the Arthur hearing, which I heard on August 8th, 2025, as well as August 15th, 2025. And likewise, today was the day that I put on the return on the order to show cause for witness Erica Lugo to appear in this courtroom in front of me at 8:45 a.m. Mr. Percio, I did read everything in the court file. I saw all the pleadings that have been filed. Is Ms. Lugo here this morning?
I have spoken to her. She said.
Let's put your hand up. Oh, all right. So that being the case, it will probably be my intention to continue the hearing at this point. Mr. Gibson, you got the witness present now. You can call the witness, ask whatever questions you want.
I do, Your Honor.
All right. Would you like the client to sit over there with you?
I would, Your Honor.
Okay. Mr. Baker, you can go over there and sit with your lawyer. All right, so let me dispatch with the rule to show cause first, and then we're going to resume the hearing. Ms. Lugo, can you step up here?
This is a witness? And now they're going to go away? Oh, I guess they go on a little bit longer.
Good morning. You're Erica Lugo? So, Ms. Lugo, listen, that you did appear, so at the end of the proceedings this morning, I'm just going to dismiss all this. That's going to be done. But just so you understand, because I read all the pleadings that you filed, all the rules apply the same, whether it's a civilian, whether it's a law enforcement officer, whether it's the state that subpoenas you, whether it's the defense that subpoenas you, anyone. If you get a subpoena, you got to come to court and answer the subpoena, all right? If the lawyers want to ask you 100 questions and your answer to all 100 questions is, I don't know anything about that, you still got to come and do it, all right? So the rules apply to everyone. The last thing in the world that I want to do is put witnesses in jail. I just want witnesses to appear. That's the defendant's constitutional right to put whatever evidence he wants in front of me or in front of a jury. It's also the state's right to put
a little
whatever evidence
louder?
they want to put in front of me or in front of a jury. So, any questions for me about that? Okay. So, Mr. Gibson, you want to call Ms. Lugo as a witness?
Yes, Your Honor.
All right. So, Ms. Lugo, you can have a seat in the witness stand right there. So once you're seated,
Ooh, it's
I'll
buzzy.
get you to scoot that chair forward as far as it'll go.
Okay.
You can adjust that microphone so it's pointed directly at your mouth. Raise your right hand for me. Swear to tell the truth, whole truth, nothing but the truth.
I swear to tell the truth and nothing but the truth.
Okay, you can put your hand down. Can you please state your full name and spell your
All right,
full
so
name?
she's loud.
Erica Lugo, Erica. Lugo, Lugo.
Mr. Gibson, you may inquire.
Thank you, Judge. Good morning, ma'am.
Good morning.
Do you know Andre, or did you know Andre McFadden?
Yes.
Would you tell this on the court, if you recall, the first time you ever met him?
Back in like 2012.
Is it fair to say that you knew him from over the decade?
Yes.
You ever met this man here to my left?
Never.
Have you ever seen him before?
Never.
Have you ever rented a car that was to be used by him in New Jersey?
Never.
Did you make a police report that a vehicle that you had rented for Andre McFadden had stolen?
No. I plead the fifth.
What?
No problem.
I never rented a vehicle for Andre McFadden. I rented a vehicle for myself.
Did I mishear, or I'm in a bit of a quandary?
No, hold on, man.
Oh.
You ask your question. The lawyer asks the question. The witness answers the question.
Can you repeat?
Go ahead, sir. Ask.
Wait, what are we watching? Look at the judge's face. Oh, we're at the wall! They took us to the wall. Chat, it's our fault. I know we're watching this late, but I feel like it's our fault. We tune into something and we just get I plead the fifth? And now we're looking, this is why we're looking at the wall, guys. I don't think they came back at all. What is going on? Well, that was messy. Now I'm stuck. Now we've got to watch this. We've got to see what happens. Oh, chat. That was quick. That was quick. Well, good morning, good morning. Let's hit play. Let's make sure we're now we're just gonna wait. And hopefully they were told in advance, like, you know, if you don't remember something, just let us know. You know, I plead the fifth is a specific thing. It is not the same as I don't know, or I'm not sure, or your question's really poorly worded. Can you ask it again? Oh my gosh. Oh my god, chat. I can't believe it. Let's see. Let's see if we have any updates over on X about, you know, what they're doing off the camera. No, I don't think I see anything. Kathy only just like reshared that the stream was live, so let me search for Bortlen and see if there's other people in the courtroom that I don't already follow. Nope. Nothing new. We're gonna sit here looking at a wall all day if they don't come back, chat. Um. Okay, so let's see. Where's yesterday's hearing? I guess we could watch this in the meantime if you want, from yesterday. I can keep both windows up so we can hear if court comes back. It is a nice marble. All right, so yesterday's hearing clip. Oh, I think, was there motion on the screen? This is yesterday's hearing. I don't see a stream from Law and Crime for an earlier hearing. Let me try spelling his name as Cortlen. Yeah, no, the only streams I see, at least from Law and Crime, are yesterday's stream and then what's on right now. So yeah, there's motion in the court. There's like people moving, like their heads are on the bottom of the screen. But we could do a quick, let's watch the plea deal. this might be a little quiet too. So let's turn this up and I'll put up a banner. Closed captions.
Yeah. Well, at this time, Your Honor, the state would move what has been already provided to Your Honor.
Let me go back on there. He's already got it. That's labeled up there.
All right, let me go back on the record. This is State
my
versus
God.
Cortlen Henry, 19-1871 CF10A and 23-10643 CF10A. I continue to have Ms. Collins, Mr. Griffiths present for the state, Mr. Haddad present for Mr. Henry, who continues to be present. State, yes.
As a formality, the state would move at this point what has been provided to Your Honor previously in reference to State's Exhibit 1. It's the two points that Your Honor already talked about on your files that the state already discussed, that Your Honor reviewed by stipulation of the parties and had completely introduced that as evidence.
Okay, so any objection? All right, without objection, Ms. Wilcox, we'll call this State's A for identification. It's going to be in evidence only for the purposes of this hearing. That's State's Exhibit 1.
I had talked.
Hey, Emma.
I had got repeated the other day, my voice kind of stuff about doing arguments tomorrow. But I better.
We have no objection to that. So.
That's fine.
And I may put them on,
That's fine.
but I can't talk, I'm going to do it tomorrow.
State, you have no other evidence or witnesses or testimony you want to present today.
No, Your Honor, just argument.
And Mr. Haddad, whatever evidence, witnesses, or testimony you want to present, you want me to do that tomorrow? All right, that's no problem.
I also, with the state motion, between stuff.
Oh,
Except, you know, like, I don't know what to call it.
we filed the state's motion for relief from the trial order.
Yeah, to file your motion in limine.
Correct, but I think we agreed that that's moved because he doesn't intend to call.
The two witnesses. All right, I'll handle that when we do the arguments tomorrow.
Just so Your Honor knew it wasn't something that was
Understood.
heavily litigated.
Yeah, that's fine. So the only thing I'm going to press pause on the all pending motions. And again, we're going to resume tomorrow at 9 o'clock. That's the defense motion to suppress. I'll give you a ruling on the state's unopposed motion for relief from the trial order, as well as the state's motion in limine. But I'm going to let each side continue to present whatever evidence, witnesses, or testimony they'd like to do before that. So I'm going to pause on the evidentiary portion today. I do want to have a quick conversation with Mr. Henry. I'm going to put him under oath, talk to him about the charges, make sure he understands the maximum possible penalties, make sure he understands the state offer.
I think that's something else that defense wants to speak to him about.
Yeah.
Well, I'm going to put it on the record right now, but he doesn't have to tell me what his answer is now. But I just want to make sure he has all the info. And what I'll tell you all, I'll be back here tomorrow, and then, you know, I'm going to tell Mr. Henry this as well, but for his benefit now, if he wants to resolve the cases by way of a negotiated plea, that's fine with me. And if he doesn't want to, that's fine with me too. But the one thing that I am going to change, if you need me to, I can put him on maybe Tuesday afternoon, the 9th. I'd rather just not do it. I'd rather know yes or no the day before, because there's a significant, number one, I don't want him to feel any pressure. But number two, I got 250 citizens coming in here Wednesday morning, and there's
Tuesday
just,
afternoon is fine, Your Honor.
yeah, if need be.
I have a hearing at 3:30.
It's fee hearings, you know.
Yeah, so I don't really have to say.
But I'm going to be here,
But,
right?
yeah.
Okay. All right, so Mr. Henry, listen, I'm going to put you under oath and ask you some questions, okay? It's only going to be as it relates to the state's offer, and it's only as to make sure that you understand the state's offer and you understand the charges that you're facing here. We're not going to talk about anything else. So just listen to my questions and answer the questions, okay? Raise your right hand. You swear to tell the truth, whole truth, nothing but the truth. Okay, you can put your hand down. Please state your full name. How old are you? How far did you go in school? Do you read and understand the English language? Are you presently under the influence of any drugs, medication, or alcohol? Have you ever been treated for a mental illness? Are they giving you any medication in the jail right now? All right. How are you feeling this morning? Your head is clear? You understand what's going on? All right, so Mr. Henry, listen, you got two cases. I'm going to go one at a time. In case number 19-1871 CF10A, right now, you're charged as follows. Counts 1 and 2 is murder in the first degree with a firearm. Those are capital felonies, which means it's a mandatory life sentence. If the jury convicts you of count 1 or count 2 as charged, that's life in Florida State Prison. I have no discretion. Count 3 and count 4 are accessory after the fact to murder in the first degree. Those are each first degree felonies. The maximum penalty for each of those is 30 years in Florida State Prison. Okay? In your other case, which is case number 23-106 CF10A, you're charged as follows. Count 1 is tampering with a witness in a capital felony. That is punishable by life in Florida State Prison, all right, as the maximum penalty. Count 2 is directing the activities of a criminal gang. That's a first-degree felony punishable by life, so the maximum penalty there is also life in Florida State Prison. Count 5 is conspiracy to commit tampering, and again, as it's charged, that is also a life felony. The maximum penalty is life in Florida State Prison. And lastly, count 7 is unlawful use of a two-way communication device. As that's charged, it's a second-degree felony. The maximum penalty is 15 years in Florida State Prison. So right now, as to all the charges that you're facing, the maximum possible penalties are as follows. It's life in Florida State Prison, followed by 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 75 years in Florida State Prison. Do you understand the charges and the maximum possible penalties involved? Okay. So, Mr. Henry, the state is telling me that they're extending an offer to you, and the offer is as follows. In case number 19-1871 CF10A, they're going to null pros or drop counts 1 and 2, both first-degree murder charges. Okay. And in exchange for that, as to counts 3 and 4, in that case, the accessory after the fact to murder in the first degree, you're going to plead no contest to both of those. And as to the 4 counts in case number 23-10643 CF10A, you're going to plead no contest to all 4 of those counts. And in exchange for all of that, the state is offering that I would adjudicate you guilty and sentence you to the bottom of your sentencing guidelines, which is 195.45 months, about 16, it's a shade over 16 years and 3 months, 16 years and 3 months. All of those sentences will run concurrently, that is at the same time with each other. I would give you credit for all the time that you have served, understanding that you have a lot less credit time on the 23 case because it's a newer case. So that is what would be controlling. Whatever credit time you have on the 23 case, you could subtract that from the 100
I think
and...
he actually has more time on the 23 case than the 19 case out of custody.
Oh, okay. Well, whichever case you have more time, less time in custody, that's what would happen. And you get the credit for all the time that you've served. And again, that sentence would be 16 years, a shade over 16 years, 3 months in Florida State Prison. I would have to order restitution. The state would tell me the amount of that restitution. That restitution would be joint and several with any of your other co-defendants. If any of the other co-defendants were convicted at trial or entered pleas. In other words, the restitution only has to be paid once, but each person is responsible for 100% of it. All right, but as soon as it's paid, it's paid. I would have to impose mandatory court costs in each case, and I would have to impose a mandatory cost of prosecution in each case, which is $100. So, Mr. Henry, do you understand the offer that the state is making to you? Okay, the 16 years, 3 months, and a shade more. So I'm going to pause on it at this point, Mr. Henry. It's going to give you some time, whether that be tonight or also over the weekend, to talk to your lawyers about it. Make sure they answer all your questions, talk to your family about it so you can make a decision as to what you want to do. Now, let me explain this to you, sir. I can't make the state make you an offer, and I can't make you accept any offer. I'm just the referee, okay? This is a business decision between you, your lawyers, and the state. And if you want to accept it and resolve both cases that way, that's fine with me. And if you want to have a trial in both cases, that's fine with me too. It doesn't matter to me in any way, shape, or form. But whether it be tomorrow, when I see you tomorrow, and then Ms. Wilcox, she already has tomorrow at 9 o'clock, that'll remain on. But I'll put them on both cases as well next Tuesday, which is September the 9th. Let's just call it 1:30 in the afternoon. September the 9th at 1:30 in the afternoon. We'll call it trial status in both cases. That's when we're gonna have to finish this conversation, Mr. Henry, and you're gonna have to tell me that either that you understand the offer that the state's making, that your lawyers have answered your questions about it, and then you're gonna have to tell me what your decision is, whether you want to accept the offer or whether you want to reject the offer. Mr. Henry, the one additional thing that I like to talk to people who are sitting in this situation that you're sitting in right now, and I have this conversation is as follows. The reason that I'm doing this is because I want the record to be clear what the state's offer was, and the record to be clear that you understood it and that you had enough time to talk to your lawyers about it. You had enough time to talk to your family about it. You weren't under any pressure to make a decision, whatever you thought was in your best interest. Because it goes kind of like this. And and I'm sure your lawyers could speak to it better than I can. If you accept the state's offer, that's fine. And again, if you don't accept it, that's fine too. But if you don't accept it, and one of these trials doesn't go your way, and you end up with life in Florida State Prison, which is a mandatory sentence on a lot of these counts, usually people in that situation, then they'll file what's called a motion for post-conviction relief, and they'll say, hey, Judge, my lawyer never told me, I didn't know that I could resolve all this for 16 years and 3 months, and if they would have told me that, I would have done it. And now I'm sitting here with a life sentence. So that's the reason I'm having this conversation now, so the record's going to be crystal clear on that issue. If it doesn't go your way, that argument's not going to be available to you to come back and say, hey, my lawyers didn't tell me about this, or I didn't know about this, so that's why I'm talking to you about it now.
Hey, Survivor
So,
Speaks
Mr.
is
Henry,
over on
do you have
XChat.
any questions for me
Hey.
about the maximum possible penalties involved and what the state's offer is to you as we're talking about it right now? Okay. All right, so I'm going to pause on that part of the conversation, and we'll finish that other part of the conversation either tomorrow or next Tuesday afternoon. I'm going to leave you on for tomorrow, all pending motions, which is September the 5th at 9 o'clock. I have one other matter that I need to handle prior to that with Mr. Gibson and Mr. Percio. I don't imagine that's going to take too long. And then I'll be right with you all tomorrow. And then Ms. Wilcox, we're going to put both of Mr. Henry's cases on Tuesday, September the 9th, 1:30 p.m. We'll call that trial status, and he remains set for trial in both cases on Wednesday, September the 10th at 9 o'clock, understanding that if we go forward with the trial, it's going to be on the murder case, the 19-1871 CF-10A. State, is there anything else that you need me to do regarding Mr. Henry today?
No, Your Honor.
Mr. Haddad, anything else you need me to do regarding Mr. Henry today? Okay. All right, so we'll press pause at that point, Mr. Henry. I'll see you tomorrow at 9 o'clock, which is Friday, September the 5th. Ms. Wilcox, does that otherwise conclude the FT docket for today?
Yes.
Okay, so the FT is otherwise going to be in recess until tomorrow, which is Friday, September 5th at 8:45 a.m. I hope you all have a good rest of your afternoon. All right, Mr. Court Reporter, that is it.
Heck yeah, Robert's over on X as well. I hope you're doing well, Robert. We're spreading the gang into different territories. Oh, I think they're back.
I'm not a lawyer.
Oh, I love Mel. Let me link you guys to this, and then we'll hop over to today's hearing. Hello, Mel. And I'll update my banner. Okay, let's go back like a minute to make sure we don't miss.
Slide page 3, State versus Cortlen Henry, 19-1871 CF-10A at 23.
And actually, guys, if you're just jumping in now, so today's hearing, we were just watching yesterday's hearing about the plea deal information, what was offered to Bortlen. We started to watch today's hearing, but the witness that gets on the stand after like 2 questions pleads the 5th, and then they've been in recess since. So we're getting back into it to see what happened.
0643 CF-10A. I continue to have Ms. Collins and Mr. Griffiths present for the state. Mr. Haddad and Mr. Nascimento present for Mr. Henry, who likewise is present. So I heard the evidence yesterday in the defense's pending motion to suppress statements of Cortlen Henry. State, am I still correct? There's no other additional evidence, witnesses, or testimony you would like to present as to that motion?
Correct.
In defense, there is no additional evidence, witnesses, or testimony you would like to present as to that motion?
We would like to present the testimony of defendant Mr. Henry
Oh.
for the limited purpose of what happened.
Okay, no problem. Mike, can you hear him over there? Or do you want me to do it? Yeah, Mr. Henry, just, you can stay right there with the lawyers, just speak loudly, okay, so we won't hear the answers. Raise your right hand for me, please. You swear to tell the truth, whole truth, nothing but the truth?
Yes, sir.
Okay, you put your hand down. Please state your full name and spell your full name.
My name is Cortlen, C-O-R-T-L-E-N, H-E-N-R-Y.
Okay, sir, you may inquire.
Thank you, Judge. Mr. Henry, We just want to talk about what happened in the hospital on October 26, 2018. Do you recall driving to the hospital? You got to speak up, answer yes or no, so this to happen.
Yes.
Okay. And then at some point, when you were brought to the hospital, were you placed into a room? When you were placed in that room, approximately how many officers were present?
5 or 6.
Minimum?
5 or 6.
And approximately, if you can remember, how long were you in the hospital prior to the 2 detectives arriving and speaking to you? So you were there for a little bit before they got there.
Oh, wait, what did you say?
The detectives.
For the text when we talked to you?
And describe to me the room that you were in. Was it were you there by yourself or other people in the room?
It was like a private hospital room. Probably maybe like 4 different officers in the room. And they had some outside of the room.
While you were in that hospital room, at any time were you placed in handcuffs?
Yes.
Do you recall who placed you in handcuffs?
It was one of the officers.
You're saying one of the officers. Are you differentiating officer versus detective?
Yes. One of the officers that were standing with the room.
Okay. And while you were in that room prior to giving your statement, was there always an officer in the room?
Yeah.
And at any time were there any officers in the doorway?
Yes.
What were they doing?
They were just standing there.
At any time prior to giving your statement, did you feel as though you had the ability to get up and leave? What do you think, in your mind, what was your impression that would have happened to you had you tried to leave?
They wouldn't let me go.
Prior to, well, prior to you giving your statement to the officers, the detectives, at some point were the handcuffs taken off?
Yeah.
Why?
They wanted me to go and take, they wanted me to go take a piece of
The urine set?
it.
Okay. Was there a bathroom inside the hospital room?
No, they walked me.
Okay, you said they walked you out, one of the
One
officers?
of the officers, one of the deputies that was standing guard in the room, they walked me out and walked me into a separate bathroom, restroom outside the room.
Okay. And at that entire time while you were providing a urine sample, was there always an officer with you?
Yes.
And after you gave the urine sample, did you get brought back to the room? And then at some point, there are 2 detectives that come in, right?
Yes.
At any time during your interaction with those detectives, did they tell you to agree to leave? So then the first question.
Okay, cross-examination, go ahead.
Right. So now the state is that was defense asking questions.
Mr. Henry, you were taken into the hospital room for medical treatment, correct?
Yes.
You're aware that there is no urine sample in evidence, or collected in evidence.
As loud as you can.
No, I'm not aware.
You stated you were handcuffed. How long were you handcuffed for?
Most of the time I'm
Hey, Bakers.
in the room in the hospital.
So you were handcuffed for over 2 hours in that room, which you're testifying to.
Yes, until I could go.
You say twice
Until they said I could leave, so I could.
Did you ever try to leave?
No.
Did you ever ask to leave? Did you ever discuss with the nurses that you wanted to leave?
I made it lag. My bad. Hello to all the bakers in the chat.
I'm going to show you what's being marked as states. For evidence. Do you recognize this picture? Who's that a picture of? And where are you? Are you wearing handcuffs in this picture? This time I'm in states B and evidence in states 2.
Any objection?
No objection.
Without objection, states B for identification is now going to be in evidence. That's states exhibit 2, only for the purposes of this hearing.
Mr. Henry, you agreed to ride with Detective Toyota out to the crime scene? Where you said the crime occurred? Did you ride with Detective Toyota, who testified yesterday,
Yes.
out to where you said the crime scene occurred?
Yes.
And you were seated in the front seat with him?
Which I'm going to object, it's outside the scope.
Well, it is outside the scope, but over the defense's objection. Go ahead, sir, you can answer the question.
You did not ride with Detective Toyota?
I mean, in the front seat.
You were in the back seat. Okay. And at the end of your interviews with the detectives, they offered you a ride home, correct? They did not offer you a ride home? And they did not give you, law enforcement did not give you a ride home? No further questions.
All right, based on that, any redirect?
So just briefly on the photo.
Yeah, let's go for it.
Mr. Henry, this photo that you were showing of you in the hospital, do you recall pictures being taken of you? Do you recall the officers taking photos of you? Was this taken before or after the handcuffs were taken?
Objection, Your Honor, I said he doesn't recall this decision.
Hold on, over the state's objection. Go ahead, sir, what's your answer to that question?
That was after.
You said you recall some photos being taken of you. Those photos that you recall being taken, were they taken before or after the handcuffs were taken? After. No further questions.
Based on that, any recross?
No, Your Honor.
Mr. Henry, I got a couple questions for you. You didn't get arrested that day, correct? How'd you get home?
Family friend came to me.
Someone came and picked you up from the hospital? And do you know what the time period was between that day and when you actually did get arrested?
That was October 26th. I was arrested January 28th. 2019.
All right, state, based on my questions, do you have any additional questions?
No, Your Honor.
Defense, based on my questions, do you have any additional questions?
No, Your Honor.
Okay. Defense, any additional evidence, witnesses, or testimony regarding the motion to suppress?
No, sir.
Okay. So it's just argument. So, defense, it's your motion, so when you're ready, take your time. Your argument in support of your motion to suppress, and I assume you want to suppress both. I heard, which I think is contained on State's Exhibit 1, for this hearing, there's two statements. There's a longer statement that's about 40-something minutes, and then there's a very short one, which is like 2.5 minutes. You want to suppress everything? Okay, go ahead, sir.
It was not Mirandized, as we know. I think the state was stipulated for that. But what the issue is obviously, he was not at the police station. It's an issue of whether he was in a situation where he should have been Mirandized. Whether the interrogation, as it were, constitutes an interrogation, whether or not it is custodial. Now, the defendant, police had a shooting. We heard the testimony that a car arrived at the hospital with two bodies in it. Mr. Henry was driving the car. Two bodies were taken into the hospital. Mr. Henry was taken to the hospital. And he told the nurse or somebody that was there that there was a drive-by shooting, and he explained to them where it happened. We know from what the detectives testified, other police people, personnel, that were present and talked to Mr. Henry, then went out and walked the scene, canvassed the scene, looking for evidence of a drive-by shooting. They were unable to find evidence of the drive-by shooting, and the detectives came and talked to Mr. Henry. You've heard the tape, and I just want to quote from this transcript of it. The defendant is confronted with, as he said, and the police corroborated there were at least 5 or 6 cops in the room, everybody around him. He was in a situation where he's, I'm going to call it a custodial situation when we get to that point. But at any rate, the statement was, the defendant is confronted with Bertrand and Moretti. Hey, Henry. Hey, man, how you doing? What's up, man? How you guys doing? Hey, my name's Detective Bertrand, and this is Detective Mark Moretti. We're here to talk to you about what happened, okay? Listen, you need to be straight up with us and tell us what happened here. My understanding, you told these officers something, but the evidence doesn't show that happened right here. That's confronting the defendant with something that's implying Moretti said he committed a crime there. He was lying to the police. So we know that they're confronting him with evidence of falsehood. Should he have been Mirandized, because the rest of the statement would be what they used to formulate the rest of the case. And I would submit to the court that the police had a duty to Mirandize him under that situation. They formulated, they have a crime, there's no question a crime committed, occurred. They called it a crime scene. The scene at the hospital was taped off. It was an active crime scene. Half the Miramar Police Department were there. 5 or 6 people were guarding him. He's in a situation where any person would feel they were not free to leave. He's in a hospital where people, he said there were 4 in the room with him. The detectives corroborated there were a bunch of policemen that around him. Was there a duty to Mirandize him? I submit to the court that in this situation, the defendant was, well, quoting from Hunter, Miranda warnings are required when an individual is undergoing custodial interrogation. As this court, this is the Supreme Court, as this court has explained, a person is in custody if a reasonable person placed in the same situation that his or her freedom of action was curtailed to a degree associated with the actual arrest. The proper inquiry is not the unarticulated plan of the police, but how a reasonable person in the suspect's position would have perceived the situation. Would a reasonable person in the situation of Mr. Henry have felt like he was not free to leave? Would he have felt like he was under arrest? The answer is obviously yes. He's there, some crime occurred. Is in a situation where the police are telling him they don't believe what he said happened. They made it clear that they think he's lying to the police. How would a reasonable person perceive the situation? You're in a hospital bed, you have policemen all around you, you're being accused of lying to the police. Would a person perceive the situation as one where they're free to leave? I submit to the court on the totality of circumstances, they would not. I concede the case states that a hospital room is not necessarily the equivalent of a police station, but it's not the place where the inquiry occurred. It's how the inquiry occurred and what the situation is, how the suspect perceives it. Any reasonable person, it's a reasonable man's standard as to whether a person would reasonably believe they were in a situation.
I'm sorry. I apologize. Just pause 1 second. This is Martin.
Yeah, I think this is more annoying than Fulton County microphones. The only person mic'd up is the guy coughing. Not the attorney was at ladies' night and rolled into court. One of those late clubs that goes to like 7 in the morning. But his arguments are good. Oh my god.
Yeah.
it's a motion to suppress, not a dismiss. And guys, he has until the 9th to decide on the deal. He would have Glanville in the microphone if we gave him a cough drop. Yeah, Jordy. Oh, that feels so good. Let's listen to the silence. Yeah, there's so much going on in this courtroom, and the microphones are picking up everything except the people talking. Except for the I plead the fifth witness in whatever case they were hearing before this got into play today. I want to watch that case now, whatever case that was with the car rental.
All right, Mr. Honor, I apologize. That was regarding a medical issue. I wouldn't have taken the call. I apologize. Go ahead.
Oh my God.
Let's go to Russ versus State, which the state relied on it so heavily in its motion because it was a hospital situation. The court stated, quite correctly, police are not required to give Miranda every potential suspect. Miranda warnings only apply in custody investigations, court cases. Then it goes on to say the reasons for Miranda warnings at this stage because interrogation and certain custodial circumstances inherently coercive. Statements made under these circumstances are inadmissible unless the suspect is specifically warned of Miranda rights until he decides to waive those rights. And then it says for Miranda purposes, custodial question interrogation means question initiated by law enforcement officer after a person has been taken into custody or importantly is otherwise deprived of his freedom of action anyway. The determination of whether a person is in custody for purposes of Miranda is how a reasonable person in the suspect's situation would perceive his circumstances, relying on Yarborough in those cases. A person is in custody, quoting from Hunter, a person in custody if a reasonable person in the same position would believe that his or her action, freedom of action, was curtailed to a degree associated with actual arrest. And I quoted that before. And that's the situation we have here. The defendant is in a room. He is confronted by the police that they don't believe what he's telling them. That he's lying to them and that he has to come clean. And then he's not Mirandized. He's surrounded by a bunch of police. He goes to the bathroom. He has police taking him to the bathroom. He's in a room where the police agree he's surrounded by police. They said there's a bunch of police. 4 or 5 sound reasonable from what the defendant is saying. They're consistent with what Moretti testified to. It's how many police are here. He's in a room. It's a confined place. He's got policemen around him. And he's confronted with evidence that he's lied to the police. Should he have been Mirandized? Absolutely. It's a statement that is going to be used against him in the obstruction case or accessory case. He should have been Mirandized, I think, under the circumstances testified to as to how this occurred. The defendant was entitled to Miranda.
Let's bump that up. Well, glad it was quiet for that cough. Let's play the cough out and then we'll raise the volume again. No, it seemed like that ticked off and got real quiet.
Yes, Judge. Starting with Mr. Henry's testimony, he's clearly not being forthright with the court. As Detective Cox, or Officer Cox testified, testified to when he first got to the scene, Mr. Henry was sitting outside on a stone bench when he went over and asked him what was going on. When he is questioned in the room by the detectives, they testified he is not handcuffed. In the photograph, he is not handcuffed. Detective Toyota takes him on a ride. If he was really a security risk, if he was really somebody they thought was a suspect, Detective Toyota never would have taken him on that ride, and they never would have offered him a ride home. That offer for the ride home is at the end of that recording, where they say, like, we're going to make arrangements to take you home. He was not a suspect. As the officers all, excuse me, the officers all testified, they thought he was a victim. He was receiving medical treatment because, as the defendant stated, he was among the people being shot at. So when we look at whether something is custodial or not, it's the Ramirez test. It's outlined in Ross, which is the manner in which the police summoned him for questioning. He was not summoned. He brought himself to the hospital. The hospital was a crime scene. There were officers there. Crime scene was there. They were processing the vehicle. They were processing the deceased. They were processing for evidence, potentially evidence physically located on Mr. Henry as a victim. The fact that the court heard the purpose, place, and manner of the questioning. This questioning was non-confrontational. He's not confronted with any evidence. They're not saying, you know, we found bullet casings, not saying we found GSR. The confrontation is, we don't think this happened where you said it happened. And if you look at the transcript, or you read the transcript, you can see that. Because on page 9 of the transcript, they're like, look, here's a crude drawing. Did you guys get off the ramp here? Did you drive past the Chick-fil-A? They're trying to figure out where this happened. As I think two of the officers joked, we were trying to figure out if we even had jurisdiction over this case, depending upon where it actually occurred. There were not 5 or 6 officers in the room. That never happened. What the officers said, testified to, is that there were officers around, you know, nearby, and there were, because this was a crime scene. There was an active
Let's run his face back, guys.
Depending upon where it actually occurred. There were not 5 or 6 officers in the room. That never happened. What the officers said, testified to, is that there were officers around, you know, nearby, and there were, because this was a crime scene. There was an active shooter loose based upon what Mr. Henry told police, because he was a victim of a drive-by, which means somebody is driving around shooting up vehicles. So of course police are going to respond to that. But he's not confronted with any evidence of guilt, and even if he is, the court's considering that, as I cite to in, Pitts, which is very parallel to this case at the end of my first section for issue 1, is even if they are confronted with some evidence of criminal activity, that does not necessarily transform it into a custodial interrogation. He's not confronted with any evidence of him committing a crime. It's just, did this happen where you say it is? And when we look at the entire context of the conversation, the tone, the manner, this is not an aggressive confrontation of him being a suspect. This is, tell us what happened. Where's the location? Who are the victims? What, did anybody have a beef with you? Are you posting on social media? They're trying to figure out what happened, what is going on, the basics of the investigation. And I believe all 3 witnesses testified, we believe he was a victim at the time of that.
I would personally use that argument, like, if they're asking if someone had beef with you, we saw from Viverito in the YSL trial. An officer, a detective, an investigator thinking there's beef isn't just, you know, me and factual liar arguing with each other. We're having a disagreement and we turn the other way when one of us walks in the room. We're going to call that a beef. When law enforcement uses beef, they like to act like there's always physical fighting, back and forth, threats, harassment, something more. So I would say that a question about was there beef between you as a two-way thing could go to show that the police were thinking there was wrongdoing on the part of Bortlen.
It's a reasonable person standard. The fact that he is having, documenting his injuries, that's normal in nearly any crime. A victim of domestic violence is going to have their injuries photographed. A victim of sexual battery is going to be transported to the sexual assault treatment center for potential examination. And they have the right to refuse, which is what the officers testified to. Had he wanted to refuse, we would have abided by that. There's no evidence, there's no evidence supporting this was a custodial interrogation or ever transformed into a custodial interrogation. Miranda warnings were never required for this because, as the officers testified to, at the time that they were questioning him, they believed Mr. Henry to be a victim of this.
Oh my god, the facial expression. I think the state has the stronger argument, the stronger position here. I hate to say it, but they're coloring in between the lines with the leeway they have to define what constitutes custodial.
But if I may, I have to disagree with the state. I do think that the beginning portions of the transcript were replete with instances of the detectives confronting Mr. Henry with what they believe evidence of him lying and not telling the true story of what happened to him. We see it in the second question. First question is Henry, but the second question is the evidence doesn't show that it happened there. I mean, you lied to us. You're not telling us the truth.
There you go.
Three, we see them confront him on the bottom. Here's the hard part. We're having a real hard time trying to understand is that we shut down the entire area. We had officers on the shoulder walking out. They didn't find as much as one shell casing. They go on, but they end with nothing to what you said adds up.
There you go.
You're not telling us the truth. We think there's more to this. Later on, they go on. We should expect to find evidence here, and it's surprising that to him. Right now, there's nothing. Okay. I kind of think I know what happened because I got information that something else happened on the east side of the city. But you know, it sounds similar to your thing, but you need to tell us. You need to be straight up with us, okay? Next question. You're doing your friends a disservice. So repeated examples of them telling him at the beginning of the statement, what you said to us is untrue. You are lying to us. We've done an investigation. The evidence that we have doesn't match what you're saying. We're confronting you now with the lack of evidence to support your story. So clearly, they're confronting him with evidence of his guilt or involvement in some way in either the accessory after or the murder itself. And as far as arranging for a ride to go home and being in a ride along with the officers, that matters not as to what the environment was when Mr. Henry gave his statement in that hospital room. He has testified to this court he does not feel this free to leave. This court's going to evaluate that based on a reasonable person standard in his position. Whether or not he's in handcuffs when the statement occurs, again, matters not. There are officers. He was not free to leave the hospital room to go to the restroom. I think it's easy to understand that had he stood up and walked out of the hospital, they would have stopped him. He had been there for some time before the statement occurred. They were collecting evidence. There was a crime scene, including evidence, GSR in his hands, taking his clothes, things of that.
There you go. That's a good argument.
Things that a reasonable person would not understand to be happening to a victim of a crime, but someone who may be a suspect of a crime. And at the very end, Judge, whether the officers have testified they believed him to be a suspect or not matters not, as the case law tells us. In Stansbury versus California, 511 U.S. 318, the police officer's subjective view of the individual is not bearing on whether or not the person believed they were in custody, whether they express it or not to you. It's what happened to Mr. Henry that day, and was he reasonable in believing he was not free to leave? Was his physical emotion or was his right to decide what to do next curtailed by the action of the officers? And we would submit that it is clearly, if you evaluate it just in the vacuum of that room prior to the statement. Thank you, Your Honor.
Okay, listen, although normally the best practice would be for me to give you all a written order on there, I'm just going to go to the bench because of the time constraints that we're under here, and we set the trial. We're going to commence the jury selection next Wednesday. So regarding the defendant's motion to suppress statements of Cortlen Henry, number one, I find witness Jordan Cox to be credible. I find witness Stephen Toyota to be credible. I find witness Mark Moretti to be credible.
Oh.
For the most part, I find witness Cortlen Henry to be credible.
Oh,
So
okay.
maybe as this handcuff issue, I just don't know. There's no evidence in front to the contrary. So let me put a couple things on the record right up front. Number one, it's clearly interrogation. Okay, there's no issue about that. They're asking him questions like, did you fire a gun that day? Did you have a gun that day? All right, those are questions that are meant to elicit or could elicit an incriminating response. It's clearly interrogation. that's not an issue. Number two, certainly the best practice would be for homicide detectives to just advise the person of his rights. And were they to advise him of his rights, then we don't have to go through this 2-day procedure, and I'm not called upon to make this determination. But for whatever reason, law enforcement doesn't really seem interested in doing that on a lot of these cases, so I have to make this determination. So really, the whole ballgame here is whether he's in custody. And I'm familiar with the case law that the state cited. I've reviewed it again. I'm familiar with the case law the defense cited. I reviewed it again. The bottom line is, I don't think he is in custody. And I'll put the reasons why on the record. And let me also make this clear. If I had a photo in front of me, and I don't care where it was taken, if it was taken outside in the bay of the emergency room entrance, if it was taken inside the hospital, I mean, there's video cameras all over these hospitals, maybe not in the treatment rooms, but if I had any picture or any video of anything anywhere that at any point in time Mr. Henry had handcuffs on, I'd probably feel differently about this, but I don't. I have nothing that supports that in front of me, number one. Number two, they did in fact let him go. Number three, I think this defense is trying to give law enforcement too much credit. This is just a few hours after a double homicide occurs. And they're trying to, I guess, infer some nefarious purpose on behalf of law enforcement, that they knew Mr. Henry was a suspect, that they knew Mr. Henry was going to be charged. This is the perjury trap that the defense relies on or mentions in their motion. I don't think they had any idea what had happened up to this point. It was just a few hours after a double homicide. They're just trying to figure out what's going on, to the point of putting Mr. Henry in a car and driving him to the scene that he says where this took place, because they're trying to figure it out. So they had no idea what was going on. They certainly didn't have any idea that Mr. Henry was going to end up being a defendant in this case. That seems to be corroborated by the fact that he doesn't even get arrested until more than 3 months after the fact. If he had ever asked to leave, I would feel differently about this. If he had ever told any witness anywhere that he didn't want to talk to them anymore, I would feel differently about this. He did no such thing. Again, based on the totality of the circumstances, I'm supposed to determine this. I listened to the questioning. I agree with the state in this part. It wasn't what I would call an intensive or aggressive questioning by the detectives based on their tone of voice and based on what they're trying to find out. They actually kind of go out of their way several times to say, listen, we don't care if you had drugs. We don't care if you were committing another crime. We don't care about anything else. We're homicide detectives. We're trying to find out what went on in the homicide. As to the defense's argument that there is a large police presence at the hospital, I would suspect that if any person in this room drove up to a hospital right now with 2 dead bodies in their car, there would be a very large police presence that would respond almost immediately to that location. So that in and of itself doesn't really sway anything in my mind. I think any reasonable person would have to expect that you drive up to the entrance of an emergency room with 2 dead people in your car who were shot, that you're going to be confronted with a rather large law enforcement presence almost immediately. So again, based on the totality of the circumstances, where I do find that the best practice would have been to advise him of his Miranda rights, and where I do find that this was in fact interrogation, I do find, based on everything that I've put on the record, that Mr. Henry was not in custody.
So state wins.
Therefore, respectfully, the defense motion to suppress both the statements is going to be denied. I'll enter a written order that reflects such. If and when we arrive at the part of trial where the state tries to introduce this, that would be over the defense objection, which I would consider to be preserved, renewed, and contemporaneously made. So I'll enter a written order as to that. Next, state, you filed a state unopposed motion for relief from trial order dated July 8th, 2024, and that was for the purposes of filing a motion in limine to exclude the testimony of potential witnesses Michelle Boutros and Christine Bradley. I think you all told me yesterday the defense has no objection to your unopposed motion for relief from the trial order to file the motion, number one, and number two, the motion in limine is otherwise moved because they don't intend on calling Michelle Boutros or Christine Bradley as witnesses. State, is that correct?
I believe that's still correct.
Okay, is that correct? Okay.
The way it stands, I don't believe we would.
All right, so.
And should that happen, we can address it.
Okay, well, as far as the motion for relief, just to file your motion, that's granted, and I'll enter a written order as to that. Regarding the state's motion in limine, I'll defer on that, and I'll enter written order. And if no one calls them as witnesses, it's not an issue. And if someone's going to call them as a witness or wants to, I'll address it and give you a ruling on that. And if that requires me to send the jury out and even take a proffer from either one of these witnesses, it doesn't seem like it's going to be too long in time. But I'll take a proffer from them if I need to, outside of the presence of the jury, before I make a ruling. Although I can tell you, I have no policies, but as a general rule, credibility of witnesses is always at issue. So if we're talking about the credibility of a witness in the case, a witness that one side or the other side needs the jury to believe, to have the jury believe their version of the facts of the case, then I would probably be hard pressed to say that I would prevent any witness testimony in front of the jury in that regard. But I'll enter all three of those orders today. Ms. Wilcox, this one on top is granted, the reasons stated on the record, and then the motion limited underneath is deferred for reasons stated on the record.
The motion hasn't actually been filed yet, we just have to file.
Oh,
the
you're gonna
motion
file it.
early,
I'll
so
consider it.
I'll file it today, but we won't.
Do they have a
send
copy of it?
anything.
They already have a copy of it?
Yes, they already have a copy.
All right, so I'll consider the state's motion in limine based on my ruling granting the relief from the trial order filed today, which is September the 5th, and I will defer ruling on it based on what I already put on the record. State, is there anything else that you need me to do for you regarding Mr. Henry today?
Not today, Your Honor, thank you.
Defense, is there anything else that you need me to do regarding Mr. Henry today?
Not today. Thank you.
So
They're
Mr.
wrapping
Henry's
that up.
going to keep a couple dates. Number one, next Tuesday, September the 9th at 1:30 p.m. We'll call that a trial status. So the record is clear on this. If there's going to be some sort of resolution, it has to be Tuesday afternoon. I can't take it Wednesday morning because I'm going to have the jurors here. There's simply too much human resources involved with this. And if Mr. Henry's case does resolve, and again to repeat what I said yesterday, it doesn't matter to me whether it does or it doesn't. I have a couple other murder trials that are in line with in-custody defendants, and I will use those jurors.
Not bring him here at 5 in the morning.
Yeah, just sign it. We'll give you a blank order. Just fill it out that says I need him here Tuesday, September the 9th at 1:30 p.m. 1:30 p.m. Mr. Henry, Tuesday would be the last day you're dressed like that. If we go forward with the trial on Wednesday, I need you in your trial clothes, okay? Dress for trial on Wednesday. We're going to have jurors here Wednesday. And then he has, besides the September 9th date at 1:30, he keeps his trial dates for September the 10th at 9 o'clock.
I don't need an order for 1:30, don't open it for lunchtime.
However you want to write it up.
Yeah, when it's 1:30, they usually bring them on the afternoon bus.
Yeah,
When
that's
they
what
bring-
they just,
yeah.
I was wondering.
Don't walk over it.
Yeah.
I'll take care of it. When?
Yeah, just,
Thank you. If we're gonna need it.
okay.
Thank you.
Okay, very good. I already sent you preliminary jury instructions. For the benefit, Mr. Haddad might be the only person I haven't done this with. Mr. Nascimento did it some years ago, but I bet he remembers. And Ms. Collins did it far more recently. But on Wednesday, the only thing I'm going to do is march in 5 panels of 50 at a time. I'm going to have the same trial schedule without the case information sitting in each chair. So they're going to be told that I need them from September the 10th through up to and potentially October the 10th, Friday, October the 10th. There's 2 court holidays in there, Tuesday, September the 23rd, and Thursday, October the 2nd. I'm going to talk to each of those jurors regarding their ability to serve only as to the statutory reasons that I can excuse them. Regarding the schedule only, the lawyers won't have to say anything on Wednesday, September the 10th. Once I get 60 people is the maximum that I can see in here for a jury panel. So if and when we arrive at 60 people that tell me that they can serve, they're going to be numbered 1 through 60. They're going to come back Thursday morning. When you all leave here Wednesday, you will have a copy of my questionnaire that they have filled out. It's going to be numbered 1 through 60 and a seating chart so you know where each of those jurors are going to sit. And then starting Thursday morning, we are only going to address those jurors by their numbers. I have lanyards numbered 1 through 60. Mr. Court Deputy is going to pass them out every morning. He's going to collect every afternoon when we're done with the jury selection process. So we're not going to refer to anyone's name on the record. State, you'll know the names because you'll have the list. Defense, you'll know the names because you'll have the list. And I know the names, but I'm, again, pursuant to the pre-trial orders that I've already entered, everyone's continued to be ordered. We're not going to disclose those names to anyone else. If any of the jurors' names are otherwise released to the public in any way, shape, or form, because I've already ordered the clerk not to do that as well, I am going to conduct an investigation to determine where the names are released from. And if I find out that someone has violated any of those pretrial orders that I entered, I will conduct an incorrect indirect criminal contempt proceeding immediately. So I would highly hope that everyone will comply with those orders. We're only going to refer to the jurors by number starting Thursday morning. I think that's it. State, anything else you need me to address before we recess until Tuesday at 1:30?
No, Your Honor.
Defense, anything else that you need me to address until Tuesday at 1:30?
No, sir.
Okay, so I'm going to see Mr. Henry next Tuesday, September the 9th at 1:30 p.m.
Not see you next
Division,
Tuesday.
Ms. Wilcox, that concludes Division FT for today. Division FT is going to be in recess until Tuesday, September the 9th at 8:45 a.m. I hope y'all have a good rest of your morning. All right, Mr. Court report. That is
All right. Well, that was pretty efficient, I think. And for the confusion, let's make sure they're not saying anything. Before the confusion, Bortlen has until the 9th to consider that plea. And Sunshine, hilarious, instruct Detective Columbo to dress accordingly. Corky says, I wonder if this hearing will sway his plea decision. You never know. I mean, I think it's kind of cool that this time frame for him to consider is preserved. I feel like I wouldn't know what to decide anyway, and especially if I think I'm innocent, right? If I think I'm completely innocent, there's always the urge to take it to trial and not just say, I'm guilty. But part of the plea, it sounds like they're letting him plead no contest to some of the charges, which was interesting. I didn't catch that detail yesterday. But again, we won't know what he's going to decide to do. I mean, I doubt he's just going to launch out today and make some type of announcement. But really, he has until the 9th to decide. So he did not take the plea at this point. He has until the 9th. What that means for Melly is probably something to the effect of Melly did the killing. Melly is the shooter. Melly took out Juvie. Melly took out Sack Chaser. And sure, I was aware of it, but I only helped cover it up after it all happened. Something like that might be what we get as testimony against Melly. And remember, for anyone that didn't follow YNW Melly, the first trial, that ended with a hung jury. So that's why we're getting a retrial, a second trial here. We've had changes of attorneys, changes of prosecutors, a whole mess. So, and yeah, I have big questions here. Sheriff Chuck says if they're giving him this much time, their case may not be that strong. Or, I'm not going to just say but the bigger target is Melly. So there's that. And guys, this all started, especially for everyone that joined late, this started to cover the story, an exoneration story of Brian Hooper, who was exonerated after 27 years. In July, the actual person that did the murder he was convicted of, he was initially convicted of three murder counts, one victim. The person who actually did it came out and confessed in July. So Brian is now exonerated. That's how we started this stream. But we also went down, we talked a little bit about updates in the ASAP Rocky, Relly, and Joe Tacopina civil trial. And then we just covered today's hearing for YNW Bortlen. Again, the main channel I've been catching updates on YNW anything has been over with Flesh of the Gods. I watched the entirety of Trial 1 with Legal Vices, and really wish he was still here with us to do Trial 2. But if you're looking for, I think it's cool to go watch Trial 1 back when it was happening. Totally recommend Legal Vices. He's no longer with us. He sadly passed away, but his content lives on. He lives on through his YouTube videos. So great place to go and check that out. But again, if you're just tuning in now, this stream covered 2 other things as well. I'm going to parse them out separately in case you want to watch any one thing. But other than that, we've got to pick a new redirect because we kept going and now my redirect is no longer any good. So I think Recovery Addict is still live. Let's see. Let me double check. I think Melanie Little is live again. Melanie Little is doing Cardi B. So very different from her usual Massachusetts shenanigans is usually the content over with Melanie. We've got, let's see. Let me refresh it. Alternate corner, let's see. It's still live doing Austin Drummond. And it's really not giving me that many others that are live. Because Broken Baker, we were going to redirect over there. He's not live anymore. He came over here. So we lost that raid race today. Again, I think Baker has, we're like 3-1 chat. Baker's raided us 3 times, and we've only gotten over there once. So we've got to push back next week. We've got to go raid the Bakers. Oh, goodness. But tomorrow, by the way, I put it in the chat, but Broken Baker will be doing his 3-year anniversary stream. So if you're looking for something to do on a Saturday, if you want to catch Baker when he's live, any reason, whatever the reason is, dropping the link in the chat again, since we can't raid him today. There's that for tomorrow, and it's scheduled for 2 p.m. Eastern, so that'll be super fun. And Factual Lie, thank you, just dropped Legal Vice's Melly Trial 1 full playlist. Totally worth a watch. Just great all-around commentary, great person, miss him a lot. Dolly's court hopping. We can redirect over there if you want. Let's see. Why isn't it? Dolly isn't coming up in my. It's not showing. Okay, I have to search for it and then I see it. And when we say court hopping, it's really cool, you know, watching one hearing over in one courtroom somewhere where there's a camera pool where the judge streams their courtroom. As soon as case ends or there's a break, we hop somewhere else. We find something interesting. Dolly does it. Recovery Addict does it. A few channels do the court hopping. I think Nick Starro started to do it as well with Judge Simpson and a few others that you guys love. But I love the court hopping streams. It's a bit casual listening. It's like, you know, shows like Family Guy. You can watch an episode of Family Guy and it's not, you don't need to know all of the other episodes to understand and enjoy a standalone episode. And court hopping with these smaller cases, it works like that. You don't need to follow it for weeks and weeks and weeks or try to catch up on anything. It's really casual, fun listening. So we'll do that. We'll hop over to some court hopping. I will update the description of this video to reflect that we covered like 3 different things. And let me see. Save this redirect. Big thank you to Factual Lie for dropping the links. Thanks to the mods as always. And Jim, if you're still in the chat, are you going live today? We'll give him a second to see if he's here and gives us an answer. Because he should be talking about Pat Labat.